All right, welcome back to the Williams, Elleby, Howard, and Easter YouTube channel. This is part 2 of our $7.2 million medical malpractice wrongful death case. Today we are going to kick down those courthouse doors. We're going to walk into the courtroom to try this case. But before we do that, if you haven't seen the previous video about all the work that went into the pretrial process, Mark, do you want to catch us up on the basic facts of the case?
Sure. So we represented a woman whose husband had died at a hospital in Albany, Georgia. He had gone to the emergency department with abdominal pain, and he was an older gentleman who had had prior abdominal surgery. We claim these were red flags that should have almost demanded that a CT scan be taken of his abdomen so they could see what was going on. A CT scan was not ordered in the emergency department. It finally was in the hospital hours later, but it was done on a slower speed, not stat, and it came back after he died, and a coroner did an autopsy and found that he had bled to death while he was in the hospital.
Yep. So here we are, day one of trial. The reason we are here, day one of trial, is because we had done all of this work. We had gathered all of this evidence to prove that there was mistakes made in the hospital that caused this man to die. We had exhausted all settlement offers. The highest amount that the defense offered us prior to this trial for the death of a husband, a grandfather, a good man, was $350,000. That was it. So we had no choice but to try the case in order to try to get a fair amount. And I think it's also important to note that we actually gave them a chance to settle the case for $600,000, which was a bargain basement number for the death of a husband and grandfather. And they said no. So we had to try the case in order to get a fair deal, and it turned out bad for them. So if anybody ever takes this case and tries to say this is some jackpot justice, we need tort reform, we need all this, then think about whether you would trade your husband or your wife or your grandfather or your grandmother for $7.2 million. I would venture to say that most people would say, keep the money. We don't want your damn money. You keep it in your hospital bank account. Give me my husband, give me my wife, give me my grandfather back, and that would be it. But you can't change the past in a lawsuit, and the only thing that the law allows you to ask for is money, because we can't bring somebody back to life, and to get justice, that's how we have to do it, because we can't put somebody in jail for making a terrible mistake when they're practicing medicine. And so sometimes those mistakes when you're practicing medicine have dire consequences, just like they did in this case. So anyway, I'll get off my soapbox now. But we're walking into the courthouse. We have myself, Mark, our co-counsel out of Macon, as well as our client, the widow of the deceased, with us. The defense has 3 lawyers, a jury consultant, somebody that just sits back and tries to look into their crystal ball as to who might be good or bad for them in the case. We don't do all that. We've hopefully over the years have honed our craft to be able to do that ourselves. And then they also had a hospital representative. They had the 2 doctor defendants with them, all sitting at their table.
The wife, the fiance of the doctor, friends were coming in,
Yep.
Dad of one of the lawyers.
All of those people were over there. So we get to trial, and the first thing that happens is voir dire. Some people say voir dire. Some people just call it jury selection, but we had 48 people brought in from the community there, and we had to ask these people a series of questions about their life experiences, about their thoughts on the world, about their thoughts on medical malpractice cases, about their thoughts on lawyers, and all kinds of things, to try to make sure that the 12 people that were ultimately selected to be jurors in this case, the ones who would make the decision on who wins and who loses and how much to award, if anything, would be fair-minded, or at least as fair-minded as we could possibly get in that county. So the way that process works is us as the plaintiff's attorneys got to ask all the questions first, and then after we're done with our questions, the defense attorneys, the doctors for the hospital physician group, and the doctors got to ask some questions. And we were able to identify a few people who either worked at the hospital or had some really strong feelings one way or the other about who should prevail in the case. And those people were what we call stricken for cause, meaning that they had an obvious bias in the case, that they couldn't be neutral, and so they were let go. And then once they were let go, we go through what we call the selection process, where the court will give, in Georgia you get 6 what we call peremptory strikes. The plaintiff will look down and say it's juror number 3 that we feel like couldn't be fair, or for whatever reason outside of prejudicial, like race or sex or something like that. Could be they looked at us cross-eyed or something, we didn't like it. But you get 6 peremptory strikes and they alternate plaintiff, defense. And then once those 12 are gone and all the strikes for cause are done, then the court will call out the first 12 that are left and then seat them in the jury box. And that's what happens, and that's your jury. In this case, we happen to have 2 alternate jurors as well in case something happened to one of the jurors, because it was going to be an extended trial. But we had 14 people sitting over there, 12 from, if you will, the main jury, and then 2 alternates in case something happened. And then everybody else was dismissed, and then we moved into the next stage of trial, which was
opening statements.
Yep.
And it's an interesting process, because by the time you get a jury, you've given a few facts about the case, but you're not allowed to say too much. You've tried to identify people who could hurt you so you can get them off. And then you get a jury that in large part is what order they were sitting in when they were assigned a jury number. And at that point, you then have to go into opening statements. And as the judge will tell the jury, that's not evidence. The opening statements are what the lawyers expect to prove at trial. Mm-hmm. And in our case, it was Joel did the opening statement, did a great job. And you have to inform the jury. You have to inform them in ways where you're turning complex medical ideas into language that anybody can understand. And you give a preview of the evidence. What you always have to be real careful of is you don't want to give a preview that you don't think you can prove. Yep. You don't want to make a promise that you don't think you can keep. And you have to set the tone that we're credible people. And we'll get to this by the end of the trial, but what was interesting to me in this case was the defense in their opening statement gave a preview of 10 experts that they were 8 experts plus the 2 defendants who they were going to call. You covered it in your opening statement, and as we'll talk about in a little while, not all those people wound up showing up to trial.
Yeah, that's right. And in this case, we did something that's somewhat unique to this case that doesn't happen in every trial, but there were certain exhibits and pieces of evidence that everybody agreed should be admissible, like the medical records, for example. So we just jointly moved to admit those documents and exhibits into evidence before opening statement, which allowed both sides to utilize those materials during opening statement, so we could kind of show the jury, okay, we think these 10 pages from the medical record are going to be very important, and that you should pay close attention to these pages anytime something comes up. During trial, we were also able to use demonstrative exhibits, meaning illustrations and things that aren't going to go back with the jury, but help tell the story. So in this case, but we had, for example, a clock that showed the time that the deceased was admitted to the hospital, the amount of time that he was in there, and we kind of shaded it in green during the whole time that he would have been able to be saved, or the doctors had done the right thing. And then it kind of shaded into orange and red that showed the time that it was probably too late to save this man. So it's just a visual example of things that the jury should consider. And also, as part of the PowerPoint, we used, this was a great idea that Marc had, like red flags. And we told the jury, hey, these things we think are really important as to where the doctors made mistakes. And we just called them red flags, meaning that his age was 66 years old, meaning that he had had prior abdominal surgeries, meaning that his presentation was intractable vomiting and nausea over a 3-day period, so something was obviously seriously wrong. All of these things they should consider that they either didn't or they minimized those things. So we set the tone, and then we also talked about what we believed were the defense's strongest arguments that we had kind of caught on to during the discovery process of the case, to kind of soften the blow, if you will, but also just to be completely honest with the jury about the good facts, about the neutral facts, and about the challenging facts about our case. And the whole idea is to tell the truth and give the jury the facts that they need to make a right decision, whether the facts are in your favor or whether the facts maybe pose a significant challenge for your case. You want to throw it all out there in a nice, neat, organized fashion so that they have a good understanding of what the evidence is going to be and what you expect the evidence will show. So yes, I did the opening statement for us, and then the defense did their opening statement. It's very similar to what the plaintiff does. They present the facts as they expect them to be. And then once opening statement is done, then you move into what we call the plaintiff's case in chief. And that's where we start calling witnesses. And there's a lot of strategy that goes into the plaintiff's case in chief. We had to put a lot of thought into the order of the witnesses and how we were going to call them.
Yeah, and we have a list called the order of proof. And that thing got changed about 20 times, including the day before trial.
There were a couple of trees that died as we were trying to get that put together.
Exactly, and it's a very strategic thing. For instance, we needed some witnesses to do what's called lay the foundation for evidence so that other witnesses could testify about something down the road. Mm-hmm. And so you have to put those witnesses at the front end. We had one witness we were going to call, but then we started kind of getting a bad vibe that might not be the thing to do. So then we decided to put that person towards the end of the trial. One of the things we had to decide was call the defendants for cross-examination in our case, and we had to decide what order to do that in. And so this became an entire discussion between Joel and me and our co-counsel. And with three lawyers, we all had different opinions, but fortunately we all had enough experience that we could figure out together what we thought would be the best presentation, both from a legal perspective and a persuasive perspective.
Yeah, and part of the process is figuring out what order to call the witnesses in to tell the smoothest story as possible. Like, what happened here, and call them in order as to how the story would make the most sense. But there's also other things you have to think about, and we had to think about. Some witnesses are going to be stronger than others for your case. Some witnesses may take on some water or have knowledge of facts they're going to have to testify to that aren't great for your case. And so you have to figure out, all right, well, do we want to take on water right out of the gate, or would we want to bury that in the middle, or do we want to push it off to the end? How do we want to handle all that? So we definitely had to consider all of those things. And I'll be honest with you, we literally made a last-minute decision right before trial. No, it was during jury selection as to who our first witness was going to be.
Yeah, and one of the big decisions in the case was, a lot of times in a medical malpractice case, I'll call one of the defendants as my first witness. And there's a rule in Georgia that allows us to call the defendant, and we get to cross-examine them, and the other side doesn't get to ask any questions. Mm-hmm. And it's a very effective tool. But in this case, we had some medical literature that we thought would be very helpful to our case. And in order to get that in to cross-examine those defendants, we needed to call one of our experts first to do what's called lay the foundation for that literature, to say this is reliable, it should be considered by the jury. And so we made the strategic decision to call one of our experts first to lay that foundation.
Yeah. For any lawyers or law students out there, it's Rule 803.16. Exception to the hearsay rule.
803.18.
18, sorry. There's a lot of exceptions to the hearsay rule, but 803.18. And yes, there's one aside, and I'll go through this really quickly, is that when you're introducing learned treatises or peer-reviewed journals, that kind of thing, to cross-examine an expert with, in federal court, you can use that literature with your own experts. In the state of Georgia, outside of federal court, you cannot. But the rules say you can use your own expert to lay the foundation for that, and then you can cross-examine the defense's expert or your adversary's expert with that literature. There were some rulings made at trial that we felt like were pretty clear reversible error, where the judge was not going to allow us to use our own experts to lay the foundation for that, and that caused a whole host of problems during the trial. But we were able to work out an arrangement with the defense where we could use that literature at trial. But it's so important that trial judges are knowledgeable about this rule, especially in complex cases, because it's very clear based on the case law in the state of Georgia, as well as some of the, like Carlson on evidence. And Carlson is a professor at the University of Georgia.
Mild professor.
Yeah, like the man when it comes to what the evidence rules are in the state of Georgia. He's written 2 treatises on it and updates them consistently that says that is what you do. But our trial judge in this case had a hard time grasping that concept, despite the fact that we had the Carlson treatises, despite the fact that we had case law that was printed out for him, and it caused a lot of problems in the case. So anyway, it's a good idea if you have something coming up like that. Maybe even, I think if I learned one thing from this case, it would be if I've got something like that coming up, it's probably better just to go ahead and submit a trial brief ahead of time if we expect that the judge is going to have a hard time with a legal concept, so that the judge doesn't have to make that decision on the fly. But then when you do that, you have to walk this line between, do you let the cat out of the bag and let the defense know what's coming, or do you wait until trial to address it? And
One of the many strategic decisions you got to make.
that's right. There's no right or wrong answer to it. You would hope that the judge is just going to get it right, but judges are human beings as well as we are, and sometimes they're not going to get it right, which is why we have appellate courts. And in our opinion, in this case, the trial judge did not get it right on the literature. Perhaps if we had to do it all over again, we could have gone back and written a big long trial brief, but it didn't seem like that complicated of a legal concept. And but then again, we were in a small town and the judge doesn't have to try a lot of these cases. So anyway, it is what it is. It came in the way it did.
And one of the interesting things about this literature is it was medical literature that really supported our case. It said the same things our experts said, and it said the opposite of what the defendants were saying. So we thought having this neutral articles by experts who had no dog in the fight would be pretty important.
Yeah, who not only did they write the articles, but it was reviewed by experts in that field. It was edited by an editorial board, and then it was published and put out to other medical professionals as being reliable and things that they should consider and look to when determining how to treat a patient with a certain condition.
Yeah. And we had two articles that one I had found right when the client hired us in the first place, and we had had it for 2 years. We knew we were going to use it. It was great. It was very helpful. But when we were getting ready to try the case, I was supposed to cross-examine one of the defendant's experts, who was this big muckety-muck from University of Virginia, and he was going to come testify at trial. And when I was preparing for that, I actually asked ChatGPT to find me articles that he had edited or written that said the things we wanted to be said, and lo and behold, ChatGPT produced an article edited by this expert that said the opposite of everything he had said in his deposition.
As much as I poo-poo AI and the practice of law, there are ways that AI can be utilized behind the scenes. It's not going to shouldn't be going in and trying a case, and it shouldn't be telling you what your case is worth, but it can help you with research and finding things that might be helpful.
Yeah, I don't practice law with ChatGPT, but I use it as a tool to help me find resources.
That's right, exactly. So ultimately in this case, our witnesses that we called in the plaintiff's case in chief, I'm going to get this wrong on the order, but we called our two experts. A general surgeon was one expert to talk about why what the other doctors did caused this man's death, or what could have been done to intervene and prevent his death. We called a ER and hospitalist expert that talked about what the standard of care was, what should have been done by the ER physician as well as the hospitalist. We called, obviously, the defendant doctors for cross-examination, like Mark was talking about earlier. We called two individuals that were corporate representatives of the hospital to talk about things that were available to these doctors, what was available in the medical records to these doctors, had they decided to order a CT scan and find out what was going on in this man's abdomen. And we needed that information just to show, hey, if this ER doctor had decided to do this, he could have gotten these results back within a certain amount of time, or these other things like blood products were available to him to have in place in case something happened before the CT scan results came back, or before a surgeon could come in to fix this. We also obviously called the widow to talk about her husband and what his life was like, and we called one of his children, adult children, to come in and talk about what type of father he was and what type of grandfather he was, just so the jury would understand what kind of man this was. So, am I forgetting anybody?
You're not forgetting anybody, but there was other evidence as well, which was the medical records, which we admitted. And at the very beginning of the case, we admitted the autopsy report that showed the cause of death. We admitted the death certificate, same thing. The medical records. But also, Joel had a great idea. Is we admitted the 911 audio, which was the man who died. These were the last recorded words of his life. And Joel had a great idea that before a single witness was called, we just played that to the jury, first thing they heard, and it was giving a voice to the man who was no longer with us. But it also, he sounded awful.
Yeah, and matter of fact, I think it's important enough in the case because the doctors all said, oh, he was stable, he was fine, there was no emergency going on here, it wasn't that urgent. So, at this point of this video, let's just play the audio so you can hear it.
Now, why can I help you?
He was, I ain't Stephen Ellis in overcame, and I need to go to the hospital, and I can't get those grandkids, but I need to.
Okay, so you at what?
Park Avenue.
Okay, and what's your name?
Stephen.
Okay, I'm sorry. Okay, your phone number is 308. You weak?
I said, weak, I can't go up all the kids. You tell them that I come in through the screen down porch.
Okay, you got the door open. Let me ask you this. Do you have COVID?
No, man, no, man.
You don't have no fever? Chills.
And then I had nausea. I haven't 10 minutes from last 2 days. I can't eat or drink anything. I can't even lay down. It's nausea in 10.
Okay, so I'm going to put you weak and nauseated. That's what I'm going to put.
Good, man.
Okay, okay.
All right, thank you, man.
Bye-bye.
So a couple key moments, we've been talking about the witnesses we called, and here's some of the decisions we made and then some of the decisions that the defendants made. So when we cross-examine the defendants in our case, I have been doing this for years. I like to get a flip chart of just big old paper, and it looks like a big notepad, and I put it on an easel and I have a magic marker, and I ask the defendant questions and just ask them, hey, I want to make sure I understand your side of the story, and I write down everything they tell me, and as they're saying it, I say, did I get it right? Is there anything you would change? Mm-hmm. And by the end of the examination, I have a nice written summary, which of course I've written down a lot of things that help us, and I say, is this true? And at that point, I used that chart for the rest of the case. As it turned out later, I used it against one of the defendant's experts who said none of that was true, even though it had obviously been confirmed by the defendant himself.
Yeah, it's actually probably one of the cheapest but most effective ways to lock people in with their testimony that we had during the entire trial. I was kind of giggling because Marc's got some gray hair and he took it way back old school. And it's like, here's the flip chart. And one day you should get a chalkboard and just write it up there and be like, should I erase any of this, or are you good with it?
Hey, I've been using those flip charts since I had jet black hair, and they're a good tool. I'm never going to give them up.
Insert picture of Marc when he had jet black hair. Yeah, but that was honestly very effective because, and you never really know, is the defense expert going to admit these things are true? Are they going to say something different than what their own doctor has said? And it just so happened in this case that when the defense expert got up, he said something different, a few things different than what was on the flip chart. You were able to point that out to the jury.
Yeah, and just so you don't think I'm too old school, I took pictures of those flip charts with my phone and then incorporated them in a PowerPoint in my closing argument.
True story. True story. Okay, so we presented all of our evidence and witnesses in the case and painted this picture and told the story that this man had been bleeding prior to coming to the ER was our main allegation, but at some point he started bleeding. That led to the amount of blood that was in his abdomen that was shown on the CT scan that the hospitalist ordered. And we told the story of 3 days of nausea, vomiting, diarrhea, coming to the ER, these tests being done, the ER physician not looking at his prior medical history, not ordering the CT scan, and then being transferred to the hospital where the hospitalist did order the CT scan but didn't order it stat, and then him dying before the CT scan results coming back. And then also through those medical records, the progression of his pain level getting worse and worse and worse and worse while he was in the hospital. And not only getting worse, but changing position from the left flank area to the epigastric region, which is kind of the center of your belly, right below your sternum, showing to me that kind of said that something's moving in there, right? Which makes total sense now that we know that it was blood that was flowing into his abdomen. But we told this story as to the mistake that was made, and then what could have been done to prevent his death that was not done, and then ultimately what led to his demise and the reason for his demise. But then, once we were done with our witnesses and evidence, the defense had a chance to offer some expert testimony.
Yeah, so we rested our case, and then the defense gets to go. And they called 2 experts who were well-experienced experts at this. They hired a hospitalist expert from South Carolina and then an emergency room physician from Atlanta. And these are experts who had worked for them in the past and very qualified people. Mm-hmm. And of course, they told the exact opposite story of what we had told. And Joel cross-examined the hospitalist, I cross-examined the emergency doctor, and we took different tacks. I guess Joel went first, so you want to talk about your cross?
Yeah, so, when you're going to cross-examine another side's expert, you can be a little aggressive with it. Because the jury usually understands, like, these are hired professional witnesses, right? However, their hospitalist expert was about 5'5". She was a military vet. Came across as very sweet on the stand, and I'm like, yeah, I can't get up and be mean to this person. So I just took the tact of, these facts right here we can agree on, and I pulled a lot of it from the deposition that Marc took of her during the discovery process, and then things that were just not disputable that were in the medical records themselves, and just pointed out to the jury facts that from a logical sense did not correlate with her ultimate opinion in the case. And she actually, I think now looking back on it, may have been one of the most valuable witnesses we had in the case, because she said that the same thing should have been done in the ER that was done at the hospital, meaning that a CT scan should have been ordered. And if it was ordered in the ER, then it would have been ordered stat, they would have had the results, and then interventional measures could have been put into place. But you got to remember, her job in that case was to protect the hospitalist, not the ER doctor.
And she said she would have ordered it herself.
She did. Mm-hmm. And looking back on it, I think if I had gone after her and tried to shred her, it would have backfired. And so I had to make the decision as I was listening to her answer questions from the defense lawyer at trial, okay, how am I going to approach this? Because she does not seem like a big scary monster. She seems like a very nice person that's very smart, and I have to be very careful about the way I ask her questions so as not to offend the jury.
And that's what an experienced lawyer will do for you is, I learned a long time ago that, people want to have a bulldog lawyer who's going to get in there and chew somebody up, but sometimes that's the worst possible thing you could do. You can let the jury interpret for itself what that witness is saying, and you can do it with a smile on your face when you're asking questions, and sometimes that's the most effective thing to do.
Yeah, and you have to always be able to read the room and understand how this witness is coming across, what the jury seems to be thinking about this witness. Sometimes you get that right, sometimes you get it wrong, because juries are notoriously hard to read. They've got these stone faces a lot of times, and they may think somebody's really effective 1 minute, and then 30 seconds later, you see somebody with a scowl on their face, but they're not really scowling at the witness. They're just scowling because they're thinking about something their husband said to them the night before, right? And you just never really know what's going on. But yeah, so she was their first witness. I did the cross-examination of her, and then they called a ER expert from Atlanta, and Marc cross-examined him. But I think as sad as it is that we even have to talk about this, it's the world that we live in, and we were in South Georgia, and race plays a factor. And our deceased person was white. Both defendant doctors were lighter skinned, and the hospitalist expert was a white lady. The ER doctor expert was a black man. All 12 of our jurors were black. One alternate was white. And having grown up in South Georgia and knowing what a problem racial division is still down there, and sadly I think to some extent it's just getting worse, at least the town I grew up in, we had to be very careful about how we approached this ER doctor because he was super smart. I'm sure is a very good doctor in his own right, but he does have a flaw, and that is being beholden to the insurance industry and defendants in medical malpractice cases. 94% of the time it was, something like that, he testifies for the defense. And so he's very good at what he does, and he knows how to present in the environment that we were in. So anyway, why don't you go through the cross-examination, and I'll talk about sounds I heard coming from the jury box that made me very nervous during his cross-examination.
Yeah, so my goal in cross-examining him was to stick as much as I could to what he had said in his deposition, because this guy was enormously well qualified. He has been an expert so many times that he just comes across as right out of central casting. Mm-hmm. He's smart, qualified, experienced, and skillful. And so I thought, well, who's going to win in a battle of medicine, me or him? Mm-hmm. And so I decided to do two things. I was going to stick to the deposition testimony. I was going to be friendly to him, and I was going to use the literature we talked about. And he and I actually went to the same college, so I started by saying, hey, we both went to the same college, commiserated a little bit about the luck of our sports teams recently, mm-hmm. and tried to let him know that this was going to be a friendly examination.
And then the judge promptly told you both that your conference sucks.
Yes, he did, and he's right this year. But one of the key moments I thought went in our favor during the cross-examination was those old school flip charts. Mm-hmm. Is I put those in front of the expert and I said, now, do you agree with this? And he said, no, I don't agree with those at all. That's not correct. And then I said, well, would it shock you to know that a couple days ago I went through this entire chart with the defendant over here, and he agreed that everything here was true, and he agreed, and I even gave him an opportunity to make changes, and he said they were true. And I think it made the expert look like he was a hired gun.
Yeah.
And so I think, we scored well on that. What I was concerned about was when the defense got up, they asked some questions that frankly baited me into asking a question I maybe shouldn't have. Mm-hmm. And I used the literature that we were talking about, and this guy was totally prepared to shoot that literature down. Mm-hmm. And so when I asked him on recross about the literature, he had a pre-prepared answer that he had practiced the night before, but because he was so skillful, he did it effectively.
Well, and to be fair to you, the art of an effective cross-examination requires a judge that understands what cross-examination is.
Correct.
Meaning if you ask a yes or no question, then it should require a yes or no answer, and the witness should not be able to explain. Because the truth is that the witness has a chance to explain on direct examination and on redirect examination, and as a cross-examiner, if the judge allows the witness to explain a third time, then that is not fair to the lawyer. It takes advocacy out of it, and it just lets a professional witness say whatever the heck they want to say, which is not what the rules of evidence are designed to do.
Well, actually, in this case, thank you for clarifying that, because I had actually finished my recross and we were done.
Sat down.
And I sat down, and the witness was free to go off the stand, and he asked the judge, can I say something else? And the
answer should have been no.
And the judge said yes.
Yeah.
And the judge then allowed him to just say whatever he wanted in front of the jury, and it was about this literature.
Which is insane and should not have happened ever, and no judge should ever do that. And I will tell that judge the same thing that I'm telling you right now if I'm in front of him again, that is not what the rules of evidence are designed to allow to happen, nor the rules of civil procedure. But it happened, and then you heard the jury go, "Oh," like audibly.
Yeah.
And it was so dramatic that the defense called us that night at 8:30 and said, "We're resting our case. We're not calling all these other experts that we have." And so we had to scramble to get closing arguments ready for the next morning, when we had been preparing to cross-examine the other 8 experts that they had that they were going to be calling at trial. So, it's just one of those things. Every judge is different. Every judge is going to make different decisions. All judges have different judicial philosophies, but there's some basic principles like what a cross-examination is. And if you ask a leading question, which you're allowed to do on cross-examination, to tell a story, and the answer is only yes or no or true or false, judges that say the witness may explain. No, that's not what cross-examination is, and it should not be allowed. And every judge needs to hear this and understand it, that the witness has a chance to explain and direct, and the witness has a chance to explain and redirect. They should not be allowed to explain 3 different times, especially when they're a paid expert witness. I feel very strongly about that, if you can't tell.
I think so. But anyway, that threw us a curveball, because then the defense, like Joel said, told us late at night, we're not going to call our next 6 experts. We're not going to call anybody else. We're going to do closings tomorrow.
Yeah. Then we had to cancel the flight of our rebuttal expert that we were going to be calling.
Yeah. So and this is where preparation comes in, because Joel and I then had to switch from, I was preparing to cross-examine a vascular surgeon from Vanderbilt. I immediately had to do closing arguments.
Yep.
And this is where preparation came in. I had, of course, closing arguments that I've done in many other trials, so I have a framework I can use. And also, we had done a focus group, which we talked about in the other video, and the focus group had given us the themes we had been working through for trial, so we could plug those themes into the closing. At least that's what I did. And in closing arguments, it works where the plaintiff, because we have the burden of proof, can do what's called a first close, sit down, the defense closes, and then the plaintiff can get up again and do a second close. And Joel and I split that with different goals in mind.
Yep. And that's assuming the defense presents evidence, which they did in this case. If they don't present any evidence, then they get the last word. But if they do, then you go plaintiff, defense, plaintiff. So Marc, basically, his job was to take a lot of the evidence that had come through in the case, intertwine it with the theme, and then give a summary of what we showed and then what we believe we had proved in the case. Then the defense went for, God, it seemed like an hour and a half or so. He went for a long time. And then during the second close, I basically get up, rebut a few things that the defense lawyer said that we may take issue with, reinforce some of the strong facts in the case, and then ask for an amount to be awarded. And in this case, we asked for $1 million a year for the remainder of his life, which according to what we call an annuity mortality table said he would have most likely lived for another 14.4 years, somewhere around, I think it was 14.37, but basically 14.4 years. And then we went through the verdict form with them, explained how they could fill it out, and this, that, and the other, and then we rested. And then the the judge then instructed the jury through what we call jury instructions. And that's something that is formulated through discussion with the lawyers, and objections are made and suggestions are made and all of that. But ultimately the judge reads the jury instructions to the jury and then dismisses them to start deliberations, and then all the exhibits and everything is put together, sent out with the jury. And ultimately what the jury did in this case is they came back with a plaintiff's verdict against the ER physician, because the ER physician didn't look at the prior medical history, didn't order any CT scan at all, and then found for the defense hospitalist, because at least he did something, right? He ordered the CT. And we always kind of felt like the claim against him was the weaker of the two claims. We felt like he should have ordered it stat, but it almost seemed like a compromise verdict because they found 0% fault on the hospitalist and 100% on the ER doctor. And interestingly enough, the verdict was for essentially half of what we had asked for. So I don't know what was going through the jury's mind with that, but it would make logical sense if we deducted that they found for one of the two defendants and then they gave us half of what we asked for. So I don't know if they'd have found against the hospitalist, if it would have been the 14.4 that we asked for, or how that would have shaken down. But that's how it turned out. I think the jury got it right. They did not award an excessive amount. They award a fair amount for the loss of a life, of a husband, of a father, of a grandfather. And I can honestly understand, if I'm putting on my neutral hat, why they found the way they did for the hospitalist and against the ER doctor.
I think that was the verdict that made sense.
Yeah.
And there were a couple things that I thought in retrospect that were key moments of the trial. And one was, I think that the defense misread the jury, and they decided not to call their other experts, and they got a little, I guess, aggressive and thought, hey, we're in good shape, let's wrap up now while we're high.
They felt real bullish about their the expert they had that was a black man in front of a 12-person black jury. And I'll be honest with you, I was pretty nervous about it too.
Well,
but I was greatly relieved that was not the determining factor, that the jury saw past the color of skin and got to the facts and considered the law that the judge gave them and rendered a fair verdict regardless of, the color of any witness's skin and the color of our client's skin.
I thought it was a really affirming verdict, because I think people made a lot of assumptions about those jurors that were unwarranted.
Yep.
And those jurors,
including myself,
Yeah.
I was
Yeah.
guilty as the defense was with that, and I've never been more happy to be proven wrong. But sometimes when you live in a part of the world where race is so divisive, even if you don't share those feelings, you see it all the time, and it's hard to walk away from that setting and then believe that it doesn't play a significant factor. And having grown up down there and the defense attorneys practicing down there, we felt one way about it. But like you, growing up in Virginia and then moving here, even though racism is never completely gone, if wherever you go, it's more of a factor in some places than it is in others, right?
Yep.
And so I think Marc was the optimist. I was ever the pessimist about that. But I was more than happy to be proven wrong, because they did the right thing, and that no matter how they felt about a black man being a good doctor and being on the stand and giving effective testimony, they didn't let that color their decision on the facts of the case and what actually happened.
Yeah, and in fact, I think a couple other things were at play too, which was the defense kept making a distinction throughout the trial when the man who died, when he was telling them my pain is a 4 out of 10, now it's a 7 out of 10, now it's an 8 out of 10, they kept saying, well, that's what he was saying, but it didn't match what we the doctors decided. And to me, I think the jury felt like, and we hit this in closings, was that he wasn't being listened to, that the doctors thought they knew best, even though he was telling them what was going on in his own body. And secondly, I think the defense made a real critical error going after our client on cross-examination, and they tried to make it look like her husband was not worth anything, that he was a terrible person who wasn't worth a dime. And I think it backfired, and it gave us an opening in our closings to say, hey, here's some doctors who say that they believe in the sanctity of human life and their entire job is to save people's lives, but if they get sued, they're going to say this person isn't worth anything.
That's
and
right.
I don't think the jury liked that.
Yeah, that's about it, right? I mean, there was a lot of work. If you saw the previous video that went into getting ready for trial, there was a lot of strategic decisions that had to be made during trial, from jury selection all the way up through closing statement. A lot of anxiety, a lot of stress. But in this case, the hard work and the preparation proved to deliver an affirmative verdict for our client. She was able to know that her husband's death was not meaningless, that there was some justice done in the case. I think most importantly, regardless of the number, regardless of anything else, got the validation that her husband should not have died and there was a serious mistake made that resulted in his death. So if nothing else happened out of this case, I think the validation that we were able to deliver to the widow made everything worth it. So, well, thanks for sticking with us through this video and the previous one if you had a chance to watch it. I know it's been long, but trials are a very involved process and do take quite some time. And so we hope we've covered this one, done the case justice, and told a true and accurate story of what happened. But we appreciate you sticking with us. Again, I'm Joel. This is Mark, Williams, Elleby, Howard, and Easter in Kennesaw, Georgia. If you have any legal needs related to personal injury or medical malpractice, give us a call. We do offer free consultations, and we'll be happy to give you our opinion on whether you have a good case or not. But other than that, we will see you next week. As personal injury lawyers, we love what we do, and we're happy to share the experience we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when you're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.